All right, thank you and welcome everybody. We'll call our September 26th meeting to order. And Jeff, can you hear us? All right, cool. I know that Judge Abrams was with us and must be having some tech issues, but so that we don't delay too long, hopefully he'll be joining us soon. With that though, let's at least take the attendance of those present. Do you want to do that, Becky? You want me to do it?
I'm happy to do it, Your Honor, as long as you don't mind that I'm just going to go in the order in which people appear on my people list. Obviously, Judge Baio is present. I have Judge Rohraback, Attorney Gideris, Attorney Pocklington, Attorney Gentis, Attorney Sternberg, Attorney Salato, and myself currently.
All right. And as noted, hopefully we will have Judge Abrams back shortly. He was in here, but apparently had some tech issues. We also have a couple excused absences. Judge Spader indicated that he is still in a hearing. If he finishes early enough, he will join us. And Becky has reported that Judge Morgan indicated she's at a trial management conference. So we do have a quorum, so we can proceed. You all got the agenda. I'm trying to keep these initial agendas light. Oh, wait a minute. All is better now. Okay, so Jeff, you can still hear us. You're good. We didn't say anything substantive until just now, so you didn't miss anything. Let's start with, did everyone get a chance to take a look at the minutes that were circulated? If so, and anybody would like to make a motion to approve the minutes, that would be great.
Motion to approve.
Is there a second?
I'll second it.
All right, and was that Maria or Jenna?
Maria.
Thank you, Maria. Sorry, I was looking down and I wasn't sure whose voice that was. Any discussion? Hearing none. All those in favor? Aye.
Aye.
Any abstentions? Any nays? All right, so that passes. And now moving on to our old business, you'll recall that we started off with two topics. Again, we're trying to sort of shake the dust off, get things moving, but not inundate us with too many activities up front. So the things that rose to the top, our first topics were there's Jim Abrams, the foreclosure standing orders and the notices. You'll recall from last time that Becky had reported that she was working with Judge Bellis and Judge Bizzuto relating to the review of the standing orders and was going to be communicating to them. And I'm going to turn to her in a moment to give us any update. As it relates to the notices, Judge Morgan had volunteered to be the point person and work with Becky and Judge Bellis. And obviously she's not here, so Becky may be doing double duty. So Becky, I'll turn to you.
I'm sure that both projects are ongoing. The notice for the foreclosure short calendar has been mocked up in the software. So that's with Judge Bellis for her review. It's my understanding that new notices should come out probably, we're looking at least 6 weeks in the time frame because there is testing required because it's a separate program. And there's a 2-week lag because the notices are produced 2 weeks in advance of time. So that's the update on the calendar notices. And as far as standing orders, that's an ongoing project. I'm sure those of you internally are aware that Judge Bellis has kind of compiled everything that is out there and is going through them in terms of local standing orders versus statewide standing orders and kind of taking a poll to see what is going on with those, and they are being updated for the current term, and they will be sent to Judge Bizzuto for approval and posting on the branch's website under the standing orders. As I'm sure you're aware, the foreclosure orders are a little bit different than the rest of the standing orders because there's a landing page for them that is kind of the all-in-one repository of everything foreclosure related. So it's my understanding that that's a useful tool for practitioners as well as clerks because it's kind of the one place they can go where everything's listed out. So I believe that feature will be retained, although not everything in there is technically a standing order. It's all related to the foreclosure process, which is a very as you all know, particular area of the law with its own requirements. So I do anticipate that that landing page will remain, but the separately signed standing orders and some of the forms will be updated. And legal with judicial is, I guess, the governing body. That's who owns the actual forms themselves, and we'll be providing updates. We take suggestions, and Judge Bellis is undertaking a review, like I said, to see if there are updates required. So that's the status on the standing orders.
And I'm going to open it up to questions, and I'll hold mine except for the first one because it relates to sort of the summary too. Becky, were you able to, you indicated you were going to talk to Judge Bellis about our interest in being involved in whether it's providing suggestions somehow with regard to the standing orders as it relates to the foreclosure calendar. Were you able to discuss that with her, and is there any guidance for us?
She was happy to take suggestions. The calendar notice is time sensitive because the current notice that goes out, as you've all mentioned, is incorrect. It gives incorrect information to the parties in terms of having to appear and causes confusion. So as far as I'm aware, that notice will be updated immediately. And if there's feedback based upon what goes out and there's any suggested revisions that would make it more streamlined or plain language, if you will, or anything to that effect, Judge Bellis would be happy to take recommendations to further update it. Just this body should keep in mind that the software that provides the notice is very strange. It is, if you look at that notice, it's actually a quad. So there's the upper two boxes, if you will, on the back page of a foreclosure notice have set static language in them. And then we have these lower two quadrants that are a bit longer. That's where kind of the meat and potatoes goes. That's where all the instructions can go. And it all has to be able to fit into that space so that the notice can be folded and automatically mailed and things like that. So there are space constraints, but when this body has suggestions, we could certainly, there will be a little bit of give and take, if you will, because the people on the court operations end that interact with that software, there's only a few people who have licensing rights to it. We'll have to kind of figure out the spacing and the line breaks, if you will. So it looks like it should be a simple thing, like how to control your line breaks and how to control where your paragraphs go. It's a little bit more persnickety than it appears. A lot of trial and error and trying to fit things in. So just something to keep in mind, that we are, as always, constrained by space and the programming that we use.
And was Judge Morgan able to be a part of that discussion with Judge Bellis?
I know that Judge Morgan did reach out to Judge Bellis, and they had a separate conversation. I'm not aware of what all the details of that conversation was, but I do know that there was a conversation. They spoke to each other, and I believe that Judge Bellis updated Judge Morgan as to kind of what was going on. Great. I'm not sure where that left off.
Great. Okay, and as you can see from the message from Judge Spader, he is in the middle of a trial, so it doesn't sound like he'll be with us. Any questions for Becky, folks? I'll open it up to the group. No, everybody's, no. Oh, wow, that's fast. All right. So are we ready to move on to old business item B? I'm going to take the silence as a yes. All right. Thank you, Judge Abrams. Consideration of possible subcommittees now or wait. This is sort of going to be an ongoing question because it may be premature at this point, but I just wanted to get it out there and start thinking about it. I know that Judge Spader had some thoughts on potential subcommittees at some point anyway. Does anyone want to weigh in on that?
I mean, having worked, done some industry things where, big committee, then subcommittee, et cetera. One of the things that I found to be particularly helpful is sort of letting subcommittees spin off organically as the discussion goes. There may be some things that we could look at and say, we could essentially overstate the importance of and think it needs a subcommittee, and then we talk about it for 5 minutes and we realize we're all on the same page and it's not necessary and we don't need to bring in anyone external. I think it's a good idea to be constantly keeping an eye out for the opportunity or need to spin something off, especially if it gets into things that are outside of our particular expertise or something that needs a wider audience to discuss. But I don't necessarily feel the need to dive into it right away. That makes sense?
It does. It makes total sense to me. Does anyone else have anything to say?
I would agree with that.
I agree. Yeah, I agree completely. It should rise organically when you have an issue and you're like, we can't resolve this. We need a subcommittee, but otherwise don't force it.
I think we should have a subcommittee to explore subcommittees. How's that?
Well, see, clearly, Attorney Judge Rohraback is refreshed and back in the swing of things because he's awfully witty today. Not that you aren't always, Judge Rohraback, but so with the permission of the committee, then I wanted to put it out there because we had a discussion last time, and I know that we want to be continually cognizant of it. But unless there is it sounds like we have consensus, and unless there's somebody that feels strongly the other way, I will take this off of the next agenda for old business. And if something arises, we can always consider it under new business as we move forward. Is that acceptable to everyone?
Judge Vale, I had a couple ideas, and I don't know, they don't need to be dealt with through, if the subcommittee vehicle is not, the consensus is we don't need the subcommittee vehicle. I just was when I went back and looked through them, I think it raised a couple issues that I think there was, we'll see how the short calendar notices look in light of the changes that are coming through from the other side, or from Judge Bellis. There's also the issue around, there was a subcommittee on motions to open judgment, and
there were a boatload of subcommittees.
Yeah, I mean, look, I guess frankly, three of them caught my eye, like standing orders, short calendar, and the open judgment. The open judgment piece, I thought, there is a significant there is a material difference between pre-pandemic. You have a timely motion to open judgment. You would go to the clerk's office. You would get the matter written onto the calendar. There's a little bit, there's differences now doing it remotely. I'm giving you an example. I'm not trying to address this issue. I'm giving you an example of an issue. There's an issue now where you're filing caseflow requests, and the time is a little bit different, and sometimes the caseflow request may not be acted on. And that might be something that's an example of a topic that we could address perhaps through a committee as opposed to like doing in a subcommittee manner. And to the extent that there are other, I don't know, foreclosure short calendar procedures that folks feel need to be, ironed out. For instance, to the extent that we should be thinking about pro se participation and how that's going, even if it's just making sure it's going okay. There's a difference between, pro se homeowners and pro se tenants with the way that we're doing remote versus in person. And are we, is that an appropriate thing? These are just ideas of things that, if they sound like good committee topics, cool. I have no loyalty to the subcommittee infrastructure.
I mean, what I was hearing from James and it seems the consensus, and I certainly agree with it for whatever that's worth, that the committee right now, the constitution of this committee is small enough and manageable enough, and we're starting sort of slowly with the things that rise to the top, that those are, to me, those are topics that I think we can deal with as a committee, as opposed to having separate subcommittees that basically swallow the committee. You know what I mean?
Sure. No, and I think,
but please, folks, feel free to speak up if you don't agree with that.
And my recollection is that the subcommittees are more helpful for grinding through language.
Yeah.
Something like 6111 GH or those kind of things, or the frame or the wording of affidavits that need to be, like, those kinds of things are great. So yeah, that's all.
Okay, no, I think that's great. And remember too, I mean, I'm not suggesting that the subcommittees were not relevant or important at the time, but the committee was at a different time.
Oh, sure.
In the process of the foreclosure, it just, there was a need for it because of things that were going on historically. So, all right. So let me ask this then, and this may be a shorter meeting, which I'm sure nobody will be will be too upset about. I think it would be great if, well, Becky, you said the notice is going to be coming out within a couple of weeks, right?
I anticipate, yes. I don't have a hard deadline,
That's
but
fine.
it is a priority of Judge Bellis's to get that updated.
So maybe we can, when we get that, we'll all have an opportunity to take a look at it. And then we can discuss at our next meeting if we think it's terrific and we don't have anything to add, or if we have some suggestions that we'd like to at least put together to submit for consideration. Does that sound like a plan on the notice issue? Okay. Everyone's silent, but I'm getting thumbs up and nods, and I will take those. All right. And then, yes.
I'm sorry to interrupt. Do you want me to, I can send it to you once it is live, the language, and we can circulate to the group in advance of, if that would be helpful.
That'd be great. Thank you, Becky. And then similarly, with the standing orders, perhaps we can come. I mean, I guess we kind of need to wait to see. Well, I don't know. I mean, I don't want to reinvent the wheel. What are people's thoughts of, as far as our reviewing the standing orders to determine whether there are suggestions we want to make to Judge Bellis now versus waiting to see what she's put together? I don't want us to make extra work for ourselves necessarily. Yeah. So
I think we would be prudent to let Judge Bellis work her magic, and then she can deliver that to us, and then we can, if we have the, if we believe it's wise, we can respond to what she recommends.
How's everyone feel about that?
I was just about to say the same thing. I think we should let Judge Bellis do what Judge Bellis is going to do, and then we can take a look at it afterwards.
Okay, great. Does everyone else agree? Anyone not agree? The nodding. I love the nodding. All right. Is there anything, so for new business, other than we have to set aside a few moments for the Rohrabaugh pet peeves, but other than that, is there anything for new business, anything that you think that, again, without overloading, we have 2 projects that are going to be moving forward, anything else that jumps to the top right now that you think we should be considering early?
I've got 2 that may not warrant a whole lot of conversation right now, but just to float them so that people can think about it before our next meeting. First of which is, it's been my experience that it's very common prior to the mass foreclosure, the foreclosure blocks, for pro ses to be logged into the Teams meetings either in advance of the clerks and certainly in advance of the judges, and sometimes being concerned about being in the right place and whatnot. And I was wondering whether there'd be any appetite to have some form of standardized background information on the screen, or information about the cases being heard so that they knew they were in the right place. Inevitably, some attorney needs to tell, will raise their voice and say, yeah, you guys are in the right place, etc. But I wonder if there may be a desire to have that be a little bit more official. I asked Becky a couple of weeks ago about the statewide jury instruction video that all jurors are seeing, and I'm not talking about going that far, obviously, but just to have some form of uniform, even just like the state seal or something on a screen share so that people know they're in the right place and know what they're there for.
Oh, just like a static sort of like, this is the foreclosure calendar
or
kind of thing.
And yeah, either that or maybe a half step further. And back in the day, some clerks, but not others, would have like copies of the printed docket available up front so people would know what was on that particular day, what was marked ready, what was not. Just I guess I'm trying to suggest that we may want to get a little bit more information out there, either to practitioners or pro ses, on their login to Teams for a large block that wouldn't be necessary for something like a specially assigned hearing or whatnot, but just for the mass blocks where there's, a dozen, 2 dozen cases on. Just something to think about.
But as the screen you're talking about, when they log in, they would see that.
Yes, yeah.
Anyone want to pipe in?
I'm in no way asking to be held to this at all. I'm giving you my limited understanding of the technological impediments to this. So it would be something that judicial IT department would have to weigh in on, and we don't. So my understanding is that because this is a third-party application, Microsoft Teams, there are a lot of things that we can't do with it because it's just whatever Teams provides under judicial's licensing. So I'm not sure if it's a possibility or not, to be honest. I just know that it's not an application that judicial owns and judicial can like code something into. It's Microsoft Teams. As I'm sure you're all aware, it gets updated when it gets updated, and we find out about it like, oh, it works differently today than it did yesterday. There's no notice. There's no, like the system will be down for updates or anything. So I'm not saying it can't be done or anything like that. I'm just saying that that would be something that the technology department here would have to weigh in on whether or not there's something that they could customize. I know that what is within the control of judicial would be the scheduling that goes out for that. So we can control what goes out in terms of the subject line of a Teams invitation, things like that the scheduler is actively doing. That's a business process, again, constrained by whatever the character limitations and things are on that. But we have more control, at least on the court operations side, without ITD on that aspect of it. But in order for the matters to properly live stream and provide access to the courts, the docket numbers and the case names have to be in the subject line. That's where the tech pulls the information from over to remote justice and live streaming. So that's my very basic understanding of how all of that works. And I'm sure that ITD could provide a whole lot more.
Judge Rohraback.
I'm thinking of a clerk taking an 8.5 by 11 sheet of paper, taking a Sharpie and said, "You've come to the right place for foreclosures, please stand by," and putting it in view of their camera. They could turn it on at 9 or 8:30 or whatever, a low-tech solution. But if Attorney Pocklington's saying, people like, where is everybody? What's going on? So that kind of a practical, inexpensive home remedy for that phenomenon. If it's
So, and I was kind of thinking of a similarly low tech, although maybe not with a Sharpie, is that the clerk could just screen share, even if it's a Word document, just screen share that exact thing. This is the foreclosure calendar for whatever court will be starting at whatever time, or starting at, something like that. James and George, you and Jeff, well, I guess all the lawyers except the judge, you're in there before we are. So how early, I know my clerk usually logs on a half an hour before so that she's available for people when they come in, but how early do the self-reps log in?
So it used to be that once you joined, you could just join the room. Now it holds, and I don't know what triggers this, but you'll be sitting there and it'll say you'll be notified once the meeting starts, and it just kind of starts at an arbitrary time. So I don't know when that actually happens. But I have noticed this as well, that a lot of times there'll be, and it's not just self-represented parties, there'll be attorneys who call in and say, "Am I in the right place? Can anybody hear me? Does anyone know what's going on?" So it tends to be, I usually log in 10 to 15 minutes beforehand and just mute my microphone and camera. But I have noticed people logging in, but it doesn't seem to be a set time. It just, I don't know if it's when the clerk logs on, it then starts the meeting, or how that triggers.
Becky, do you know if that's what it is?
I think that's a Teams thing. So I'm going to go ahead and ask Attorney Pocklington, if when you were waiting for this meeting to start, did you get put into a waiting room?
No, just as soon as I hit the login, it logged me in, and you and George were already here.
Okay. Did George, did you have to wait? Did it say it was waiting for someone to join the meeting?
Yes. So it didn't start until you actually logged on.
So that's a Teams thing, because I didn't schedule with any waiting rooms or anything fancy like that. So that's a Teams security thing. It's waiting for somebody within the judicial tenancy to join the meeting. So that's I like Judge Rohraback's low-tech solution. That would be probably a business requirement where we would tell the clerks, your short count, your foreclosure clerk has to log in 15 minutes ahead of time, and at least put up something on the screen. They don't have to be sitting there, but at least screen share a document, or we can low tech, we can absolutely do a background with the judicial logo. That's stuff that we can add so that you can do a background. The clerk can do a background that says, please wait. But the clerk has to be logged in to pull everyone outside into the meeting. And again, that's my understanding that that those are updates that Microsoft makes for security and things like that. And then our tech department has to react accordingly to whatever Microsoft does. So I can certainly inquire further. We have a fun and exciting standing technology meeting that I get to go to.
But I don't know. I think people seem to be okay with the low tech version. Is there a need for us to ask for anything beyond that? I'll go to James, since you were the one that raised it initially. I mean, you seem to be happy with the low tech.
Something so that they know they're in the right spot. Like in my head, I was just picturing like the seal and Bridgeport 9:30 foreclosure docket. And,
Yeah.
Or New Haven 2 o'clock foreclosure docket, just so people know that they're in the right place and they know to just wait. And if individual judges want to, one of the things I have noticed, for example, Your Honor, when you start, you'll have a fairly routine bit about muting yourself, turning off your cameras and stuff like that. And if individual judges want to pre-customize their instructions, I don't see why they couldn't tell their clerks to put that on the login screen, essentially, but on the low-tech version of the login. But it's just logging into an otherwise empty meet for pro se's and some practitioners, it can be an easy to avoid problem.
The only potential issue I see, and I know this is one of Judge Baio's pet peeves, is for self-represented individuals who call in by phone, they'll have no way of speaking to anyone. This is the major issue when they call in and start talking, and then other random attorneys start talking to them, and no one really knows what's happening. I don't know if there's any way to avoid that. This has been happening even since you left, Judge Baio, in Hartford. We've had numerous people per week call in by phone and be instructed that they need to use the Teams link. But other than having the clerk in the actual call prior to the hearing starting, I don't know if there's any way to avoid those kind of issues.
That's the judge's job. It's like, okay, here's the deal. Yeah, you want to talk now, just wait. That's why we make the big money.
I think the issue is just that they aren't informed usually that they need to use the Teams link until the calendar already starts. And then by that point, they're going back and forth and interrupting the rest of the cases that are going on when they're calling in back and forth. So I don't know if there's any way to resolve this other than the clerk coming in early and just addressing anyone who may be in the call already. But I personally don't try to step on anyone's toes in that waiting room by telling people what they need to do, because I don't want someone coming back later and saying, oh, well, this attorney told me I needed to do this. I don't want to get blamed for that. So that's what I'm likely to avoid whenever that happens.
And sometimes you can always tell who the former tax are, because the urge to say something and raise your hand and be like, guys, hold on, you're in the right spot. But I'm not the one who should be telling you that. Yeah.
I would encourage, even if sometimes it's done through judicial management or by the bench at the time, I would encourage please mute and take yourself off video. There's a lot of practitioners who need that too.
Well, I think,
and
don't most of us do that? Don't most of us tell people to do that?
Some there are judges who don't like confrontation. I don't know.
Well, clearly they're not in this committee meeting.
Yeah. I know it's wild.
They chose the wrong line of work.
Listen.
Exactly.
Yep.
All right. Well, that sounds like a great suggestion, and it sounds like one that everybody's on board with. I think that we have our first proposed suggestion. We all agree?
Yes.
All right. And James, you said you had another one?
Just a little. There's minor little quality of life things that for the court as a whole and for the bar that we all may want to think about. For example, I got a call from an attorney who's a committee on a case where judgment got vacated more than a couple of years ago, but she's still receiving notices on everything because she's still technically in the system. And so stuff like that, where considering things like automatically withdrawing a committee appearance on a vacating a judgment and the little practical things like that, I'm sure we've all got. And then I don't want to steal Judge Rohrback's thunder in terms of his pet peeves, but all those like little tiny things, it might not be a bad idea to sort of circulate offline, not now, but just a list of the little tiny suggestions that things that we've all thought about for quality of life improvements for the process as a whole, and see if if enough of us are on the same page where we go, yeah, that would be nice. I don't know why we haven't done that 5-10 years ago using the automatic withdrawal of an appearance thing as an example. Just something to think about. I say that out loud, I'm sorry.
No, that's good. Anyone want to weigh in? I love the idea of us all basically putting together lists offline so that we don't take the time today. Brainstorming is good, but we don't want to spend all day doing it. And I think that's a great idea if everybody's on board with that. If you have those things, although again, even though I think George Generous stole Judge Rohrback's thunder by pointing out my pet peeve when I wasn't going to do that, but no, I'm just teasing you. I will turn to Judge Rohrback in a moment to let him address this, but does everyone feel comfortable with that? We can put together a list, send it to Becky. She can compile it. We'll put together and circulate so that, Becky, do you hate that I just asked you to do that?
No, that's okay, Your Honor.
Okay. And then we can, if we can have that prior to our next meeting, we'll give deadlines when we figure out when our next meeting is going to be. But if we have it in advance, we can look at it and then we can put that down as an agenda item to discuss those things where there seems to be commonality. Does that work for everybody? All right. Judge Rohrback?
You know, all I was thinking is it's so nice to have an opportunity to meet informally with practitioners, and at some point, I think we're on to this, it would be wonderful just to have a little bit of time for judges to articulate things that they wished attorneys better understood, and for attorneys to have an opportunity to articulate things they wish judges better understood, and kind of outside of the strictures of this standing order or that standing order, but just like, hey, we all do this. We log in on Mondays. We got to get through this lift, and the lift might be made a little bit lighter if you understood this and we understood that. That's all I have to say. I don't.
That's great. So I think that kind of, does that dovetail with what James's suggestion was with the circulation of the list, and then we could have a discussion about it?
Yeah,
does that work?
Except the extent that somebody would be afraid to reduce to writing something that they might be more comfortable saying.
All right.
But
well,
I think we're on.
We can ad lib.
Just setting aside 10 minutes for an open discussion on facilitating this process.
Okay. And Judge Morgan, thank you for joining. I know you had a TMC. You're coming just in time before we wrap up of our meeting.
Okay, sorry about that.
No worries. We're glad you're here. Walt Spader also is in a trial, so he's not here. All right. So we'll add an open discussion on for the next agenda.
And maybe I'll just give one example since I've been biting my tongue. Like, I think most judges, we want to know, is the defendant occupying the premises? Is there somebody at the house? Like, we're thinking about a human being. They may not have appeared or they may have been defaulted, but what are we dealing with here? An empty house where the lawn hasn't been mowed in 6 years, or some sick elderly person that's going to be kicked out on the sidewalk? That to me is like top of mind when I do my job. And sometimes I say to the attorneys, what's going on? I don't know, Your Honor. Like, and I guess you don't know because you haven't had to know, but it's really salient information, I think, for many judges.
Yeah, good example. Anyone else before we'll add the agenda item. We've got the list circulating. And anything else before? Judge Rohrback, did you have anything else you wanted to add on that?
I keep it to one.
All right. So anything else that anybody wanted to add, or do we think we have enough for filling? I mean, that seems to be pretty substantive for the next meeting, but if there's anything pressing that other people want to address, please let me know.
I've got one other last thing, and I apologize, I know I'm monopolizing, but just based off the conversation I had with another judge about bankruptcy stays and whatnot, I think just so we're all on the same page, if you all weren't aware, the CARES Act forbearances, we're all used to Chapter 13 taking up to 5 years and whatnot, but the CARES Act forbearances did stretch that timeline, so there is possibility that files may be on bankruptcy, affected by bankruptcy stay longer than a lot of people are thinking. It may not be a bad idea, and I know actually we've got a couple of practitioners that do more bankruptcy work than I do. Jen, I'm looking at you. But ultimately, it may not be a bad idea to think about whether the current model that we use to notify the court and parties that a file is impacted by bankruptcy stay, that practice book provision is certainly an older one, and the process is an older one, and it's something that has differed greatly from jurisdiction to jurisdiction, or just organically over the years, between how active the court is the individual courts are monitoring that, and knowing that Chapter 13 plans are taking longer than they have historically. It's certainly something to look into, whether that requires an update or not. And with that, I really am done, I promise. I'm sorry.
Anyone else want to weigh in?
I have a late quick question for Becky. I know she loves when I do this. She probably volunteered me for something while I wasn't on the call.
All the things, Your Honor.
So is there a way that we can flag not just the foreclosure cases, but any civil case where one of the parties has filed for bankruptcy, much like the way on Edison, we flag it with a C if there's a case that's been companionized or consolidated? Is there a way that we can add a code where we can flag it with a B so that we know when we're getting onto the case if there's bankruptcy that would trigger us to have a discussion to make sure the bankruptcy stay has been lifted?
Currently there is not, but absolutely we can add codes. That would be PJ Deeks group. So I could certainly, if this committee would like some investigation into that, I can certainly bring it to his group to review what would need to happen in order to do that. But yeah, that's something, I mean, all of those flags were created internally within Edison, so I don't see why that's not a possibility. It's just a question of what it would take them to be able to do it.
Thank you.
Mm-hmm.
So is that a motion, Judge Morgan?
Yeah, so I will move that that the committee investigate whether or not it's possible to create a code on Edison that would flag to users that a party has a pending bankruptcy proceeding.
And is there a
I'll
second?
second the motion.
All right.
I will second, happily.
Any discussion? All those in favor?
Aye.
Aye.
All right, it looks like that was everyone, but so there should be no opposition or abstentions. Great, motion carries. Becky, one more thing for you to help us out with.
Add it to the list, Your Honor.
Yeah. All right. So I think we should probably talk about setting our meeting schedule. I know we had talked about how eventually, or at least we said going forward, we were going to do quarterly meetings, but I don't know if the parties here would like to meet earlier than that, given that we have some action items on the table. And we know that we're rough estimate with no commitments that we're going to have the notice to review in a couple of weeks. So how do you feel about timing of the next meeting, everyone?
How about middle of November, second or third week in November?
How do people feel about that? That works for me.
I was thinking 4 to 6 weeks, so that's perfect.
The second week is what you want, because the third week is actually the Thanksgiving week.
Well, what we'll do is what we've been doing. Becky's been sending out that doodle poll, so she can do that not too close to Thanksgiving, but in mid-November, if everybody's okay with that. And then she'll pick the date that we get the most people. Does that work for everyone?
That sounds great. Thank you.
And then if we keep, we may have to do this for the next couple of meetings until we start getting our sea legs, and then maybe we can figure out a set schedule so that and have it on your calendar after the holidays, starting at the beginning of the year, where we know you have it on whatever day consistently, unless there's a need for something sooner or we need to cancel. That way, at least it becomes sort of habit. Does that work for everybody? All right. Is there any other business we need to discuss? Wow. Then I would entertain a motion to adjourn. Roar back.
I'll second.
All right. All those in favor?
Aye.
Aye.
You guys are the best. Thank you,
Madam Chair.
everybody.
Thank you. Bye.
Thanks,
All right. Have
everyone.
a great day, everybody. Thank you.
Bye-bye.
Everyone.
Thank you.
Bye.